statement that Representative Maxine Waters of California made has caused a lot of concern out there. Let me play the clip, and then we'll discuss why the defense in this particular case thinks that statement may have tainted this entire trial.
We got to stay on the street, and we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
So, Sarah, I want to move on and get our analysts to assess that, but her statement is obviously riveting within this within the trial.
Yeah, it is. And the judge admonished her. He named her, and he said, I wish that elected officials that are here to go ahead and serve the Constitution and abide by the Constitution would not make comments on this case that could possibly be inflammatory or could be disrespectful to the process, to the judicial branch, and to the jury. He was very strong in his statements. And I am sure this is not the last we've heard of Maxine Waters. She tends to speak her mind as well. But he was very, very serious about hearing from public officials and wanting them not to inflame tensions, and he said so on the bench. Wolf?
Let me bring in Elliot Williams, who's watching this, our legal analyst, former federal prosecutor. We got to stay on the street, she said. We've got to get more active. We got to get more confrontational. We've got to make sure that they know that we mean business. What did you make of how that came up at the very end after the jury already began deliberations?
Look, Wolf, come on. This story has been front page news for the greater part of a year. Movie stars, members of Congress, presidents of the United States have commented on this trial. The idea that one member of Congress's statement a few days before the jury starts deliberating is somehow going to prejudice the jury is nonsense. The law presumes that jurors can take in and internalize the instructions from the court, and the court has instructed the jurors, I guess, twice at the beginning and at the end. Number one, not to watch the news, and number two, anything they see to set aside, and they were picked on account of their ability to agree to do so. So some of this, I think, to be candid, is about Maxine Waters. But at the end of the day, one famous person making a comment that's incompatible with the trial just doesn't throw the verdict out. Now, the defense attorney has to make that objection now in order to be able to make it again on appeal if Chauvin is convicted. So some of that's just basic lawyering, but this is not grounds for a mistrial.
Ellie, what did you make of the closing arguments we heard from the prosecution and the defense?
Yeah, so, I think they both did what they had to do. And, the prosecution's goal was to appeal to common sense. One of the things he started off with was, I think you heard, I don't remember the number, I think it's 45 witnesses. The 46th witness is your common sense. And so, yes, you've heard about carbon monoxide, but there's a 9-minute and 20-second video. Yes, you heard about an enlarged heart, but there's a 9-minute and 20-second video. Yes, you heard about fentanyl, but there's a 9+ minute video. And all of these things, the defense did everything they could to throw up bits of doubt, but they just didn't address the 9-minute video. Now, again, that's their obligation. They don't have to, but the common sense plea that the prosecution went to is that big piece of evidence. Now, jurors are weird when they get back in that room, and who knows how they come down. But as a matter of straight presentation, the prosecution just had a more airtight case.
Shan Wu is with us as well. Shan, you're a legal analyst. The jurors, they got the instructions from the judge on the 3 specific charges facing Derek Chauvin. What do those deliberations look like at this point?
Well, usually, the first thing they'll do when they go back there is that they will choose a foreperson. I think of note will be, we'll learn later who it is, but, there's a nurse, I think, on there, and, people with that type of medical opinion could exert a strong influence on it. And then typically they will start to go through the evidence. Hopefully they don't immediately take a vote. Usually the judge will tell them you don't want to do that right away. You want to kind of work through the evidence in a very organized manner. I agree with Elliot. I think the defense has put on a strong case here. I certainly hope that they put on a strong enough case. I think the defense did a good job today. I think this was him at his best, the defense counsel today. He picked the pieces from his records he needed to pick. And there are some issues with regard to prosecutorial misconduct that could be, fodder on appeal as well. So I'm nervous about it. But certainly the weight of the evidence is in favor of the prosecution, and hopefully the jury will take their time and work through it. I mean, pretty soon we'll be wondering, is a short amount of time to deliberate a good sign or a bad sign or a long time? And generally, when you're the prosecutor, you want a longer deliberation. It takes a lot for people to decide that someone's guilty, so you want them to take their time.
Did you think the defense in this particular case went on and on and on through everything at the jury?
It was a little bit. He opened really weak today with his closing argument, but it was a smart move for him to try to move the time focus away from that 9 minutes. He could have done a better job with it. He was trying to show that Chauvin didn't know everything that we know sitting here calmly looking at it. There was stress. He understood what he was arriving at on the scene. He kind of put those pieces in motion, was the right idea, but he didn't really tie it together. So I also felt that when the judge broke when he did, probably the jurors had been listening for too long and needed that break, and that was probably a help to the defense. The other thing he really could have done is to really point out the fact there's a tragedy. I think he mentioned that one time, and he really needs to say this is a tragedy, it's a horrible thing, but let's talk about if there's enough evidence to convict Chauvin. I don't really think he did a very good job of that.
Sarah, the prosecution told the jurors to, quote, use your common sense, believe your eyes, what you saw. Just how important was that 9.5-minute video of George Floyd on the ground there with Derek Chauvin's knee on his neck?
Yeah, I mean, they saw a lot more than 9 minutes and 29 seconds of Chauvin's knee on George Floyd's neck. They saw all of the video of all of the officers who were there and involved. And then on top of that, they saw, of course, the bystander video. But the reason why the prosecution changed that number, because at first it was 8 minutes and 46 seconds is what they initially charged. Later, they reduced that to 7 minutes and 46 seconds. But when they saw all of the police video, which the jury saw, they upped that number. It's a long time to have your knee on someone's neck, and they kept making that point over and over and over again. I got to tell you, seeing that video again, over and over and over again today was hard to watch, just like it always has been. I think the jury is certainly going to have a hard time as they have to go back through it, because they can certainly look at that video if they want to try as they're deliberating this case. But I want to say, when we also saw a rebuttal after the defense went, who talked a lot about the medical condition that George Floyd was in, the drugs that George Floyd took. The rebuttal and the words from Prosecutor Blackwell were pretty strong. He ended today with the jury saying, the truth is George Floyd is dead because Derek Chauvin's heart was too small. And you remember that there was an argument about the slight enlargement of the heart of George Floyd as a potential reason. I think the prosecution very much jumped on that and left the jury with something to really think about.
Yeah, that's an important point. Elliot, the prosecution said, and I'm quoting now, they said this wasn't policing, this was murder. How effective was that closing argument?
Yeah, so I think that was sort of the Goldilocks closing, trying to find something that appealed to everybody. Because remember, this is Hennepin County, Minnesota. Once you get out of Minneapolis, it's not the same demographics that you're going to find in Minneapolis on the jury pool. And the jury pool is drawing from all of that. They had to speak to both people who might be inclined to think about the reform of policing and sort of, the bases for the protests over the last year, but also people who might be inclined to buy some of the arguments that the defense is putting forward, more sort of traditionally, quote unquote, pro-police folks. And if you, Jerry Blackwell sort of and Steve Schleicher earlier in the day made clear, talked about policing, what the badge means. Policing is a noble profession. And I think that was incredibly deliberate language meant to tug at the strings at a certain type of juror, just because you don't know what's going to resonate with the group of 12 that has to rule unanimously.
Let me play this clip. This is the prosecutor, Steve Schleicher, making his point. Watch this.
Only you have the power to convict the defendant of these crimes, and in so doing, declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first. When you saw that video, it is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse.
That's how he summed it up. Shan, let me get your reaction.
Well, Wolf, my heart is with him completely on that, but I have to say, as a former prosecutor and defense attorney, he's walking right up to the line there legally. He's got to be careful with that on appeal, that it's very strongly an appeal to emotion. I think that part's effective, but you got to be careful with that when you're on the prosecution side. Referencing your gut, dangerous. Common sense, okay, but gut and emotion, that's a little bit dangerous, and I think it was powerful, but they're taking a little bit of a risk with that. And I think they are trying, as Elliot said, trying to appeal to a broad base of people there. They're trying a little bit of common sense, a little bit of the law, a little bit of emotion, and I hope they got the mix right.
Because, Elliot, you heard the defense attorney, Eric Nelson, make the point that he felt that there was evidence of a potential mistrial, that there was a prejudice there as a result of what the prosecutors were saying. What did you think?
Again, the law presumes that the jurors can listen to what a judge instructs them about an attorney's arguments. There was a lot of back and forth today over, did the prosecutors go too far? Did the defense misstate the law? And the judge's ruling was ultimately that, number one, I'll give the prosecutors a chance to clean this up on their rebuttal. But more importantly, I can instruct the jurors that, number one, what the law is, I, the judge, state what the law is. And number two, follow the instructions and go from there. And so, again, the law and judges and courts don't want or presume that there ought not to be mistrials, and you can correct ways around them. The defense had to make these arguments, put them on the record, so that if, in fact, he's convicted, they can go back and have a basis for overturning a conviction.
Because, Elliot, you did hear Eric Nelson, the defense attorney, make the point that the jury should have been sequestered the whole time, given the enormous publicity this trial has generated.
Yes. Judges don't like sequestering jurors on account of the fact that it is incredibly disruptive. And the law sort of urges against it because of how disruptive it is to the lives of jurors. It presumes that you can find jurors who can set all of what they know aside, and you can protect them from the pretrial publicity. Now, look, this is as high profile as any trial has been, I think, frankly, in most of our lifetime, going back to, I don't know, perhaps OJ or something like that. So, this is a special trial. But again, the law seems to have anticipated for that. Now, who knows? This is what Shan was getting into as well. He has Nelson and the defense have a basis for challenging this, and they have a basis for raising it on appeal. As of today, we could have all predicted that the judge was not going to grant a mistrial based on what we saw.
Yeah, that was obvious. Sarah, you've been there, as I say, every single day. You're watching this as closely as any journalist is right now. Give us a little sense of what's going on in the community as we await now the jury's decision.
So on Sunday in the daytime in George Floyd Square, which is the area in which George Floyd died, where they have been keeping vigil for almost a year now, it was really a heartening sight. There were dozens of people out there from all different walks of life who were talking about peace, talking about trying to find justice, talking about what they were going to do going forward, and there was absolutely no violence. But you can also see around this city, on a lot of street corners, you are seeing armed National Guard. They are in uniform. There are boards on more and more and more buildings and businesses. They have moved the perimeter, and it's clear that they can close the perimeter if they need to, the way that they have built it, with concrete blocks and fencing and, razor wire and barbed wire around government buildings, especially around the court. We know that over time they have ratcheted up more and more law enforcement as well. And we understand there's going to be more law enforcement coming in from other states, from Ohio, as we heard today in a press conference. And the police chief was also asked about what his concerns were, and they're great. They are extremely worried about what the reaction is going to be to whatever the verdict is. And so if you ask people who have been here, who have been demanding justice, who have been going out into the streets every day, many of them will tell you that if they don't get the decision that they want, and I'm going to put it the way they did, this place is going to blow. Wolf?
Yeah, so Shan, let's talk about what's going on in the jury deliberation that has just begun. You're a former federal prosecutor. Typically the first thing they do is pick a foreperson?
Yes, well, that's usually what they'll do, and then the foreperson will hopefully kind of guide them a little bit through the process. And what you want them to do as a prosecutor, and what the judge wants them to do, is to kind of work their way through the evidence in an organized fashion. I haven't seen if they gave them a verdict form, but ideally the verdict form would present them with the most serious charge first. They're working their way through that, and then they will go down to the next one and then the next one. I was a little bit concerned because it's complicated, the difference between those charges legally. I want to make sure, if I was a prosecutor, that I'm really spoon-feeding how to do that to them. And I suspect we will expect some notes from the juror asking about that, so because it's a complicated issue.
To convict Elliot, you need a unanimous decision, obviously, all 12 jurors. To find Chauvin not guilty, you need a unanimous decision. But there is a possibility of a hung jury if one or two or three of the jurors have one view and it's not unanimous. There's a hung jury, right?
Yeah, I've been there. It's not a nice feeling. It's not a nice feeling as a prosecutor. What will happen, I think you'll get a sense, not to predict, but you'd start seeing notes coming back from the jurors that we are unable to come to a verdict on, let's say, count 2, manslaughter, right? And the judge will invariably instruct them to go back and use your best, whatever, I don't remember what the precise wording is, but do your best to come to a conclusion, to come to a unanimous verdict. They'll come back a day later, 2 days later saying, we can't find or we can't come to a unanimous. That tends to be the sign that a mistrial may be coming on a charge, because they keep trying to instruct the court that they can't come to a conclusion, and the court keeps instructing them that, well, you got to try to be unanimous one way or the other. It's certainly a possible outcome. Now, there are 3 different charges here, and the facts of Chauvin having encountered or engaged with Floyd aren't in dispute. The question is, did he cause the end of his life? The jury could possibly negotiate amongst themselves as to, well, we may not unanimously agree as to second-degree murder, but we could get everybody on board with manslaughter. And that happens, and that's certainly something. Now, you don't think there should be horse trading in the law, but what people do as a matter of, this is exactly what Shan was talking about with, they pick a leader, and it's, to some extent, Lord of the Flies. They as a group have to set some social order and come to an agreement. So, yeah.
Sarah, as I say, you've been watching this as closely as anyone. What do we know about how the jurors have been acting, how much attention they've been paying throughout, about 3 weeks of this trial?
It's 3 weeks, and I don't know that people know what that pressure feels like as a juror, as you are being watched by the media and by the attorneys. You are under a spotlight, even though the public is not allowed to view you. There are a lot of people in the court who are paying attention to the jury. And, for the journalist in there, and I was in there for a day myself, when you watch how they engage, where they are writing notes, they are paying close attention. There was only a day day where there was a little bit of fidgeting going on, but for the most part, they have really been engaging. When one of the medical experts that the prosecution brought in, Dr. Chauvin, started talking about, feel your neck. Let me show you what happens when this is compressed. Let me show you where this is and that is. And he was saying, touch the back of your neck, touch the... Many of the jurors were doing so much so that the judge told them that, look, you can do this, but you are not required to do what this witness is telling you. So it tells you something about how much they're paying attention, how important this is to them to get it right. And we actually heard them say those very words when they were in voir dire. When they were questioned by the defense and the prosecution as they were picking jurors, many understood how important this case was. Some of them saying they wanted to be on this case because they knew its importance and they knew it was important to get this right and to pay close attention. And I think they have had a jury that has really paid close attention and been engaged the whole time. Wolf?
Shan, if you're the prosecution or the defense for that matter, what do you do while the jury deliberates? It could go on for hours. It could go on for days.
You sweat a lot. And if you're the defense, you're trying to keep your client calm. But you're also thinking and trying to anticipate what questions could come out. Because when that note comes out, and I'm predicting we'll at least have a few notes, you're going to have to explain to the judge how you think the court should respond to that note. Sometimes you want to say, don't respond at all to improper question. Other times, you're going to make suggestions as to what further guidance should be given, and the other side may disagree with you about that. So a lot of that time is spent anticipating what issues may come up. There may be some legal research you want to shore up about particular issues. That's what you are doing right now.
Yeah, I want everybody to stand by our senior national correspondent, Miguel Marcus.
One of the important components of the community when it comes to policing, and there are several groups like We Push for Peace who have been brought in to try and help calm things down if things start to get really, really tense. And they've been in the streets for many, many, many weeks, going in and out of 38th in Chicago where George Floyd died, George Floyd Square, going down to Brooklyn Center, and during the day they put on some music, they have barbecues, they bring food, and it's a group of black men who have decided that they're from the community and they want to be out in the community, but they also want to try to calm down any kind of violent reaction to police or looting or burning. And during the day, they tend to have that effect. You also have groups like Agape. They are providing security down at 38th and Chicago. They've been down there for a while, and they've sort of turned the street energy, as they say, into community energy. And that is also a group of black men who are rising up and saying, look, we'd like to see our communities thrive. We don't want to see them hurt. But I will tell you, I've talked to several black business owners who are in and around the area of 38th and Chicago, and they're having a really hard time, some of them. They're frustrated. They feel like they've been left behind. Every time something happens, it tends to happen in and around their area. It looks blighted. There are boards up. There are buildings that have been torn completely down. Some of them were burned in the last, uprising here. And so there is a bit of frustration. There is a bit of hopefulness because there are these groups around. But the police are going to be relying on some of these groups to try and help deal with what could be another mass protest. But you may see a mass protest that is peaceful depending on what happens with the jury. And it really does depend on how the jury decides this case. Whether we like it or not, that is a huge factor in how the reaction will be from the folks here in Minneapolis and, frankly, from around the country and world. Wolf?
It certainly is. Shan Wu and Elliot Williams are still with us. I want to play this clip, Elliot, and then we'll get your reaction from both of you. This is Eric Nelson, the defense attorney, making his closing argument.
The state has really focused on the 9 minutes and 29 seconds. 9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds.
He's referring, Elliot, to the resistance that George Floyd had in getting in the back seat of that police vehicle.
Yeah, look, Wolf, if you and I get drunk and get into a bar fight, I can't then go into court and say, well, I was sober all day. before I went into that bar. The person that I knocked out, I just shouldn't be held responsible for that because I behaved myself perfectly and comported with good behavior earlier in the day. So that's a little bit of a misleading argument. Now, because this is about the reasonableness of police conduct, maybe there is space to say that 16 minutes gave officers cause to restrain Mr. Floyd, at least initially. But what the prosecution has done throughout this trial is note that 9 minutes, the 9+ minutes, tested the bounds of reasonableness. So after 10 seconds, 15 seconds, 3 minutes, 4 minutes, 5 minutes, 3 minutes after he stops breathing and doesn't have a pulse, you cannot make the argument that the action was still reasonable. So it's quite a distraction to point to that 16 minutes in light of the fact that the crime is committed itself in the course of that 9 minutes and 29 seconds.
Shan, what did you think?
Well, I think Nelson had to go there. He has to shift the focus away from that 9.5 minutes. And it makes sense for him to do that, to argue that don't view Chauvin in the vacuum of this horrible scene of him kneeling for 9.5 minutes. View him in the context, the totality of circumstances you heard him talk about, of what he thinks he's walking into. Maybe that affected what you, the jury, should think of as a reasonable response. So he had to make that argument, but I think still that does not overcome the horror of those 9.5 minutes.
Our chief White House correspondent, Caitlin Collins, has been watching all of this together with us.